The H1B Guy here, and today, the H1B Guy news for the week ending June 4th, 2021. Today, I'll cover H1B employer fraud confirmed and the Eagle Act, HR3648, introduced. Before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues and the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. Today's news is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads and local job board postings since 2001. And also by Path to Canada. Path to Canada provides an ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H-1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Path to Canada is your answer. Well, I think outside of employment-based immigration benefits that we cover here on this channel, the biggest news of the week is the 25 million COVID-19 vaccination doses that are going to be sent to India from the U.S. Hopefully that'll bring some much needed relief to the country, which has been heavily hit over the last month by the COVID-19 pandemic. Now, the news. May 28th, 2021. In a news release posted on justice.gov for the United States Attorney's Office, Southern District of Texas, titled, Houston Consulting Company Admits to H-1B Visa Fraud Conspiracy. Quote, CloudGen LLC, a consulting and strategic solutions company located on South Dairy Ashford Road in Houston, through its corporate representative, CloudGen pleaded guilty to conspiring to commit visa fraud from on or about March 2013 to December 2020. During the plea, the company admitted to recruiting multiple information technology workers from India and falsely procuring H-1B visas for them to enter and work in the United States. An H-1B visa permits the temporary employment of non-immigrants to fill specialized jobs in the United States. Specifically, in this bench and switch scheme, the company would file documents with the Departments of Labor, DOL, and Homeland Security, DHS, containing fraudulent statements about the availability of work at third-party national employers. CloudGen would then submit forged contracts stating each third-party company had a job for the individual Indian national. Next, based on those false documents, CloudGen would submit paperwork to get an H-1B worker's visa for the Indian nationals. When granted, they would use that visa to allow the Indian nationals to enter the United States. However, because the jobs were fake, they were housed in different locations across the country while CloudGen obtained other employment for them. Such action gave CloudGen a competitive advantage by having a steady bench or supply of visa-ready workers to send to different employers based on market needs when the true process actually takes some time. Once workers had obtained new employment, the switch would occur when the new third-party company filed immigration paperwork for the foreign workers. CloudGen would also extend their visas based on original false ones to allow them to stay and continue working in the United States. CloudGen took a percentage of the worker's salary as their fees, earning approximately $493,516.28 in profits during the course of the conspiracy. Chief U.S. District Judge Lee H. Rosenthal will impose sentencing September 16th. At that time, the company would have to pay up to $500,000 or the greater of twice the gross gain or twice the gross loss, as well as a maximum of 5 years of probation. Well, the good old bench and switch. That's not to be confused with the bait and switch. Neither of those two are a good thing. I will start by saying this. For all of the ridiculousness from the former President Trump's administration that was levied against H-1B visa holders, their crackdown on fraudulent filings by these so-called middlemen is one of the positives that came from their restrictive policies against high-skilled immigrants. This type of arrangement is all too common, and I honestly believe that the electronic filing process has created even more opportunity for companies like CloudGen to take advantage of the system. Unfortunately, the demand for high-tech roles only continues to grow and creates opportunities for scammers like this to benefit. Percentage-based arrangements are the norm with these types of employers. However, when companies like CloudGen withhold compensation, they need to be punished. Hopefully, come September 16th, that $500,000 fine closes their doors for good. June 2nd, 2021. In a press release posted on Lofgren.house.gov titled, Lofgren Curtis introduced bipartisan legislation to eliminate arbitrary per-country limits on employment-based visas. Quote, U.S. Representatives Zoe Lofgren, Democrat, California 19th District, and John Curtis, Republican, Utah 03 District, introduced HR 3846, the Equal Access to Green Cards for Legal Employment, EAGLE Act of 2021, a bill that will benefit the U.S. economy by allowing American employers to focus on hiring immigrants based on their merit, not their birthplace. HR 3648 phases out 7% per country limit on employment-based immigrant visas. The bill also raises the 7% per country limit on family-sponsored visas to 15%. Its predecessor, the Fairness for High-Skilled Immigrants Act, passed the House in the 116th Congress with a resounding bipartisan vote of 365 to 65. Said Representative Lofgren, chair of the House Subcommittee on Immigration and Citizenship. The basic framework for allocating immigrant visas dates back to the middle of the 20th century and was last seriously updated in 1990, when Congress established the worldwide numerical limits on visas and the 7% country cap that still exists today. The Bipartisan EAGLE Act moves our country toward a system that de-emphasizes birthplace and better serves America. Simply put, it will allow U.S. companies to focus on what they do best, hiring smart people to create products and services, which creates jobs in our districts. Representative Curtis said, the 2020 census showed that Utah has the fastest growing state in the nation, in no small part due to the major growth and innovation in the technology sector, bringing thousands of new jobs to the state. The Bipartisan EAGLE Act will create a more fair employment-based visa system by eliminating per-country limitations and creating a first-come, first-served system focused on merit instead of country of origin, making it easier for Utah's businesses to expand and compete globally. Although America's employment-based visa system starts out as a merit-based, what happens next has nothing to do with merit or skills. Visas are allocated based on the intending immigrant's country of birth. Approximately 95% of employment-based immigrants currently live and work in the United States on temporary visas while waiting for a visa to become available. Some of these individuals remain in temporary status for many years, if not decades, because of the caps applied to their country of nationality. The new phased-in system established in the Bipartisan EAGLE Act would help ease the backlog for those who waited the longest. Like the Fairness for High-Skilled Immigrants Act that passed in the House in the July 2019 bill, phases out 7% per country cap for employment-based immigrant visas and raises the 7% country limit on family-sponsored visas to 15%. Like the version of Fairness for High-Skilled Immigrants Act that passed in the Senate in December 2020, the bill includes a longer 9-year transition period to ensure that no countries are excluded from receiving visas while the per-country caps are phased out, strengthens the H1B temporary visa program, and provides an option for individuals who have been waiting in the immigrant visa backlog for 2 years to file a green card application although the application cannot be approved until a visa becomes available. Well, what great news this was, really midweek this week. And here's an opportunity for me to say, I told you so. If you recall, during my 7 predictions for 2021, I said that new legislation similar to HR 1066 S386 would be introduced. Here's our first glimpse as to what this new bill's language includes. Introduced by California Representative Zoe Lofgren and Utah Representative John Curtis, HR 3648, aka Eagle Act, includes some very familiar reform and a few new wrinkles. As I said a few days ago, I have more confidence in this piece of legislation than I do in any others in regards to immigration reform, and that it's time for the 7% per country limit on employment-based immigrant visas to be a thing of the past. Will Senator from Utah, Mike Lee, introduce a similar bill in the Senate? Does bipartisan immigration reform for high-skilled immigrants have any hope in HR 3648? I believe it does, but I've been wrong before, although I'm going to continue to hold out hope. Look for a complete breakdown of the HR 3648 text from me sometime next week. For the full post on the H1B Guy news for the week ending June 4th, 2021, please check out the H1BGuy.com. And a reminder that today's post was brought to you by RecruiterNetworks.com, the smart solution for digital perm ads and local job board postings since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad, regardless of which city you choose. RecruiterNetworks.com has been the #1 place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the perm advertisement rules. RecruiterNetworks.com. Tell them the H1B Guy sent you. The news is also brought to you by Path to Canada. Path to Canada provides an ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Path to Canada is your answer. They will help you navigate the process. If you're interested in finding out more, please be sure to click the link in the video description below. Just wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. I really appreciate your support. The H1B Guy, your global source for all things H1B.